let me be equally clear. The House of Representatives, a co-equal branch of government, was fulfilling its duty in exercising its constituent powers that even the Supreme Court cannot just take away. Hindi pwedeng basta ipawalang bisa ng Korte Suprema ang kapangyarihang ipinagkaloob ng saligang batas sa Kamara, lalo na kung maling batayan ng ginamit nito. The separation of powers is like a finely tuned scale, each branch bearing its own weight so that the Republic stands upright. When one branch acts in a way that shifts that weight, it must move with the precision of a surgeon, not the force of a sledgehammer. To do otherwise is to risk toppling the balance entirely, leaving our people with a government where one power overshadows the rest and the promise of checks and balances becomes nothing more than a faded inscription in a dusty law book. Long-established principles on judicial restraint and separation of powers have been cast aside. In Duterte, the Supreme Court painted in broad strokes, ignoring the boundaries of competence and authority it once acknowledged in Imbong versus Ochoa, GR number 204819, April 8, 2014. I quote, medyo mahaba-haba po itong quotation, but I find it very important. In many cases, involving the determination of the constitutionality of the actions of the executive and the legislature, it is often sought that the court temper its exercise of judicial power and accord due respect to the wisdom of its co-equal branch on the basis of the principle of separation of powers. To be clear, the separation of powers is a fundamental principle in our system of government, which obtains not through express provision, but by actual division in our Constitution. Each department of the government has the exclusive cognizance of matters within its jurisdiction and is supreme within its own sphere. In its relationship with its co-equals, the judiciary recognizes the doctrine of separation of powers, which imposes upon the courts proper restraint, born of the nature of their functions and of their respect for the other branches of government, in striking down the acts of the executive or the legislature as unconstitutional. Verily, the policy is a harmonious blend of courtesy and caution. It has long been observed, however, that in times of social disquietude or political instability, the great landmarks of the Constitution are apt to be forgotten or marred, if not entirely obliterated. In order to address this, the Constitution impresses upon the court to respect the acts performed by co-equal branch done within its sphere of competence and authority, but at the same time allows it to cross the line of separation, but only at a very limited and specific point to determine whether the acts of the executive and the legislative branches are null because they were undertaken with grave abuse of discretion. End of quote. A harmonious blend of courtesy and caution. Hanggang ngayon, pilit ko pang hinahanap ang sinasabing courtesy and caution na dapat nagpaalala sa ating Korte Suprema sa pagsulat ng desisyon nila sa Duterte versus HOR. We respect the judiciary. As a lawyer, I respect the judiciary. But respect must be mutual. The court must also honor the legislature's exclusive domain over impeachment unless there is clear, grave abuse of discretion or blatant violation of the Constitution, which this House most certainly did not commit. Upholding the Constitution sometimes mean checking a co-equal's overreach. In this case, it is our duty to call out the Supreme Court's encroachment on Congress's power done under the guise of procedure. Sa botohan sa Senado noong nakaraang Miyerkules, halos nag-chorus ang mga anti-impeachment na senador sa pagsasabing kailangang igalang desisyon ng Supreme Court. Pero mula pa noong Pebrero, sino ba talaga ang hindi gumalang sa mga institusyon ng gobyerno? Sino bang sinabihan ng Senate President na mali yung timing ng pag-transmit ng articles of impeachment dahil tapos na ang session at mangangampanya na ang mga senador? Sino bang inutusan ng Senado na mag-certify na hindi lumabag sa one-year bar rule ang House at niremand dito ang articles of impeachment? Sino bang tinanong ng Korte Suprema kung nabasa at naintindihan ba ng mga House members ang articles of impeachment na kanilang pinirmahan? Sino? Matapos ang napakahabang proseso sa Senado at sa Korte Suprema, ang hindi man lamang binigyan ng pagkakataon ng mag-oral arguments bilang isang co-equal branch bago isulat ang desisyon. Kung respeto lang po ang pinag-uusapan, nilunok na ng mga miyembro ng kapulungang ito ang lahat ng kanilang pride para lamang irespeto ang Senado at Korte Suprema sa kabila ng lahat ng pag-iinsulto na ginawa sa kanila. Records clearly show that the impeachment was duly initiated in February 5, 2025, in full accordance with Article 11, Section 3, Subparagraph 4, and yet the Senate failed to do its duty to proceed with impeachment forthwith. The Senate could have convened as an impeachment court as early as February or March, but it did not. Some of us in the House grew concerned at this 5-month delay, as justice delayed is justice denied. Still, the House prepared for trial, designating our House prosecution team and readying our evidence. Nevertheless, on June 10, in a twist, the Senate adopted a resolution to remand the articles of impeachment back to the House, asking the House to certify that the one-year bar rule had been observed effectively. The Senate was suspending the trial pending this certification. Alas, on July 25, without any oral arguments, the Supreme Court issued its decision nullifying the House's articles of impeachment and barred the Senate from proceeding, supposedly on the ground the impeachment was initiated more than once in a year and that the Vice President's due process rights were supposedly violated at the House level. Worse, even if the House of Representatives, through the Office of the Solicitor General, filed a motion for reconsideration, the Senate, in plenary session, voted 19-5 to archive the impeachment complaint against VP Duterte. This move was exceptionally swift, contrary to their extremely tardy action, their stalling when it came to their convening as an impeachment court. Aside from the House's motion for reconsideration, 4 other MRs were filed by movements interveners. The first group of complainants with the endorser, Akbayan Representative Percy Sendanya, Isang Bayan and the Makabayan Bloc, and just yesterday, another group of interveners, the third group of impeachment complainants, also made a plea to the court to reverse its July 25 decision. These MRs are not frivolous or sham. They raise strong and compelling arguments necessitating a serious review of the July 25 decision. At sana po, sa pagkakataong ito, magpatawag ng ang Korte Suprema ng oral arguments. The pending motions for reconsideration embody the Filipino people's concern for the integrity of the impeachment process and their call for the accountability of the Vice President. To ignore these legitimate pleas by archiving the articles of impeachment even before they're fully heard by the Supreme Court is being insensitive, not only to the demands of the lawmakers, constituents, and sectors they represent, but to public opinion as well. The Senate has not even started the trial, but it moved with lightning speed to bury the complaint once the Supreme Court gave them an opening. The Senate dragged its feet on the actual impeachment trial, but moved immediately when it came to archiving the complaint. Parang mali po yata ang intindi nila sa forthwith proceed. Forthwith apparently was observed in the breach. Ang bilis nilang kumilos pagdating sa pagsasara ng kaso, pero napakabagal nang sila hinihilingang dinggin ang kaso. If this is not a case of double standard, I don't know what it is. The irony is that following the decision of the Supreme Court in Duterte, archiving the articles of impeachment is tantamount to a dismissal. Di po ba yun ang sinasabi, yung first 3 complaints daw, when archived, were deemed or effectively terminated or dismissed. Some senators have said their preemptive vote was simply respect for the Supreme Court. But let us be honest. It is the House of Representatives whose constitutional prerogative has been disrespected. The Constitution commands the Senate to proceed with impeachment forthwith, yet it took them nearly half a year to even consider convening as an impeachment court. But when the opportunity came to archive the complaint, suddenly, forthwith, was crystal clear to them. That burst of urgency after months of delay is telling. It is not unreasonable to suspect that this timing was no coincidence, that the Senate's slow walk at the start bought time for the Vice President, for her lawyers, to reach the Supreme Court, and for the court to run the full length of its decision-making ritual. This was not respect for another branch. It was a choreography of convenience, and the House was the one made to bow. Those are the facts, Mr. Speaker, Madam Speaker, and dear colleagues. Maliwanag na maliwanag po na sinunod ng Kamara ang proseso at ang saligang batas, at hindi po ang House ang lumabag nito. If anything, it is the Senate whose unorthodox actions need defending before the bar of public opinion and when posterity will take a look at this chapter of our history. I have great respect for the Senate as an institution, having had the privilege of serving one of its former members. And I know there are senators, those who voted against archiving, for instance, who also see this outcome as a disservice to our people. But when the Senate chooses to abdicate a constitutional duty, we must speak up. We do not rise against the Senate, we rise with the Republic and the Filipino people. Tulad nga ng sinabi ng isang kasamahan natin, quote, just because the Senate dropped the case doesn't mean the issue disappears. The public is still waiting for answers. Deflection is not accountability, end of quote. The Senate President said that the Senate is not anyone's playground, and that is precisely why we expected it to rise above politics and uphold its duty to conduct a fair trial and not to preemptively dismiss by archiving the case. If this was truly about deference to the Supreme Court, the Senate could have simply suspended proceedings temporarily until the motions for reconsideration are resolved to give the Supreme Court and the House the due courtesy they deserve as co-equal branches. Instead, they rushed to archive or terminate the case. Malinaw ang mga pangyayari. Taliwas sa paniniwala ng Senate President na minadali natin ang proseso, ang Senado ang nagpabagal nito. What we witness from the Senate is not the moving of heaven and earth to exact accountability and attain justice, but the moving of heaven and earth to render extraordinary protection to the Vice President. Sadya bang napaka-espesyal ni VP Sara para ipagliban ng Senado ang impeachment trial ng halos kalahating taon? Sadya bang napaka-special ni VP Sara para maglatag ng mga bagong patakaran ang Korte Suprema na naging balakid sa pananagutan sa puntong ito? Mr. Speaker, sa ginawa ng Senado at ng Korte Suprema, malinaw na maipamalas sa ating ng pananatili ng kapangyarihan ng mga Duterte. Panganib itong hindi dapat maliitin. Hindi naman kasi imbento ang mga kasusyon natin, ang mga akusasyon natin laban kay VP Sara. Buong bayan ang nanood sa kanyang bantang ipapatay raw niya ang Pangulo, ang unang ginang at ang Speaker. Meron na raw siyang kinausap na assassin. Siya pa mismo ang nagdiin, hindi ito biro. No joke. No joke. Mr. Speaker, it is really not a joke. Under ordinary circumstances, when a death threat is broadcast live on the internet to the highest and fourth highest officials of the land, it is doubtful that the offender would remain free the next day. So what makes this instance fall outside of ordinary circumstances? First, the offender is an impeachable official. Second, she is a Duterte. Because of these extraordinary circumstances, VP Sara not only evades charges at this point, she even has no less than institutions shielding her as if her death threat broadcast live on the internet were nothing more than a joke. Si VP Sara na nga po ang nagsabi na hindi ito joke 2 beses pa. Ganito po kalakas si VP Sara sa sistema ng ating hustisya. Tila baga wala siya sa ilalim dito. Nandun siya sa itaas, untouchable, malayo sa pananagutan ng Congreso, bilang isang impeachable official na sa disensyon ng ating konstitusyon ay ang tanging sangay na may kapangyarihang panagutin siya sa puntong ito. Sana, until the Supreme Court came out with Duterte versus HOR. Kaya wag na po tayong magtaka kung ganito na lang ang kawalang respeto sa otoridad ang mga Duterte. I think that it is also the first time in Philippine history that someone challenged our top law enforcer, the PNP chief, to a fist fight. Of course, it had to be a Duterte. Yun nga lang umurong at nagpalusot. But like his sister, Baste Duterte is still free and unaccountable for what can be considered, to a certain extent, an assault on an officer of the law, or at least for committing the offense of challenging to a duel. Ito na ba ang sadyang kalakaran sa Pilipinas? Na basta Duterte, untouchable? Dapat lang tayo mangamba kung may isang buong pamilya sa Pilipinas na hindi tinatablan ng ating mga batas. Buti na lang po, yung tatay hindi dito haharap sa hustisya. Ang Pangulong Marcos Jr. na mismo ang nagsabi, walang kinalaman ng mga akusasyon kay VP Sara sa naging desisyon ng Korte Suprema. Puro tungkol sa proseso lang naman daw ang laman ng desisyon. Ayaw pa rin daw niyang makialam sa proseso dahil bilang isang impeachable official himself, maaaring self-serving ang kanyang opinyon sa proseso ng impeachment. With all due respect, the Supreme Court should take the cue from the President and reflect on the value of the President's statement that an impeachable official should be careful in his opinions about the impeachment process because they might be self-serving. Hindi nga ba may naisingit na rider sa Duterte decision na hindi pwedeng ma-impeach ang mga miyembro ng Constitutional Commissions at ng Supreme Court kapag collegial act o desisyon ang dahilan, even if treated merely as an obiter dictum in the Duterte decision? This statement on what is an invalid cause for impeachment, when this is not even the least mota of that case, is a highly irregular, self-serving rider doctrine. It is completely unrelated to the case being disposed of by the court, who should have taken a page from the President's book on self-restraint. Having said that, we also wish that the President had refrained from thumbing down the impeachment or sending mixed signals. So meron din pong kamalian ang Pangulo doon sa kanyang mga naunang mga statements noon na tila ba dinidiscourage ang House na ipatuloy yung impeachment. At least, he should have called for an all-out support on the need for accountability, even from impeachable officials. Of course, VP Sara can still be made accountable in a future impeachment complaint. But that is not the point I'm making here, Madam Speaker, dear colleagues. The point is, the impeachment process has now been made more difficult by the court's decision in Duterte, if not nearly impossible. That is why Duterte versus HOR, if not reconsidered, is unacceptable. The checkpoints and roadblocks it has erected are simply insurmountable for House members to even dare endorsing one in the near future. Accountability has never been made more difficult to achieve in this country than now. And this is the reason why I am also against, basically, the prospective application of the decision in Duterte case. There is no alternative to overturning the rules and doctrines laid down in this decision. Duterte versus HOR and the lip service it paid to due process at the expense of accountability simply has no place in a democratic republic where the people should be able to hold to account every single public official, even the special class of impeachable ones. Indeed, this fight is not over. Hindi pa tapos ang laban ng katotohanan.